In this video, we will be talking about legal guardianship for people with disabilities and what you need to know about it. I'm Craig Kahn. I've got it going on. And this is TeamAutismpedia, where we're dedicated to educating you about autism and how you can better the lives of people with autism. If you're interested in this type of content, please consider subscribing so you can get our latest content. For this, I'm deferring to my friend Kim, who is a lawyer who also knows about guardianship and will give us some of the basis so you can make some good decisions on using guardianship of someone who has a disability. Kim?
Yeah, thanks, Craig. Guardianship is a complicated subject. We're not going to be able to cover everything except just sort of touch the surface on the basic questions that you need to be thinking about if you are considering guardianship for someone who's a person with disabilities. I think the first thing we need to do is talk about, well, what does that mean? What is a guardian? And a guardian is someone who, under a court order, is given the decision-making rights of the person with disabilities. So essentially, when they give those rights, they're also taking them away from the person who has the disability. And after that court order is in place, they'll issue something called letters of guardianship, and those letters give that guardian the right to override the will of the person with disabilities and make decisions for them. And I also want to point out that a guardianship is only over the person, and it has to do with decisions about their health, safety, and well-being. That does not give them right over that person's money. That would be called a conservator or a conservatorship, and that's a different issue, and we're probably not going to get into that a whole lot in this video, but I just want to point out that there is a difference. Now, in some states, including mine, I don't know, I'm only going to be able to speak to Kansas law, but I think it's true most places that guardians can be given a limited amount of ability over finances. In Kansas, it's up to $10,000. So let's say you're a person with disabilities and you have Social Security benefits of, $500 a month. Well, that is going to be spent on that person's care. And so they're never going to have $10,000 to spend at one time. So in a situation like that, a guardian can manage that amount of money. But if they have more than $10,000, then they would need a conservator to manage their finances. But again, those are two different analyses. So what they're looking at in terms of do you need a guardian is, can you provide for your own health, safety, and well-being? And if you can't do that, then you have to consider whether you need a guardian. Now, in order to think about whether you can provide for your health, safety, or well-being, there are some questions that you need to ask or need to think about. And even if you answer these questions no, it doesn't automatically mean you need a guardian, and we'll kind of get to what that means in a minute. For example, can you find a place to live? Can you go out and look for an apartment and talk to a landlord and sign a lease and find a place to live? Can you go to the grocery store, buy your own groceries, prepare your own meals? Can you, do you work? Do you have a job? How much responsibility is it? Can you get yourself back and forth to the job? Are you able to get yourself back and forth from social activities? Are you able to arrange those for yourself? Are you able to go to the doctor on your own? Are you able to ask the right questions? Are you able to take your medication appropriately? Do you understand, what your medication is for and why you're taking it? Kinds of questions where if you answer no to any of those things, you may need a guardian. And so the next question is, well, who decides that? Who makes the decision about whether or not you need a guardian? And while the court ultimately makes the decision, it's going to be very heavily based on a doctor's report. So there needs to be, and I've seen it, so I've seen social workers write these reports, but most of the time it's a physician. It's either an MD or a psychiatrist or some physician who's familiar with the person and has examined them specifically for the purpose of giving an opinion as to whether the person needs a guardian. In my state, there's a particular form called a report of examination and evaluation that you give to the doctor that you want to do that assessment, and that doctor would be specifically making a statement, yes, I believe this person cannot provide for their health, safety, and well-being. Yes, I believe this person needs a guardian, or no, they don't. So even though you have that report, you still want to look at what is the least restrictive way to go about helping that person meet their needs for health, safety, and well-being. And it isn't necessarily a guardianship. I wanted to talk just for a minute about powers of attorney, because those are something that you might want to use in order to prevent having to have a guardian. That is basically a document that states that you give certain authority to another person to be able to make decisions for you. For example, you can do simply a healthcare power of attorney, and you can give another individual the power to talk to your doctor, have your health information, and make those medical decisions for you. If that's the only thing you need help with, then you can just do that with a power of attorney, provided you have the cognitive ability to understand what you're signing. You still have to have a certain level of competence to be able to, you don't necessarily have to understand all the legalese, but you have to know what you're doing. You have to understand the gravity of what you're doing and giving that other person the decision-making power. You have to understand what it is that you're giving them. And if you're kind of borderline where you need some help, but you can't maybe do everything, then potentially you could just use a power of attorney. You wouldn't need to go the guardianship route. And it's very subjective. When that doctor fills out the report, he's going to be, or he or she is going to be defining words like can, can't. They're going to be defining, whether you're able to do these things. So it's always going to be to some degree subjective. And it's certainly possible that you could have two different doctors come down on two different opinions with regard to the same person. But let's say, just for the sake of the discussion, that you have quite a bit of need. You've got someone who isn't able to really understand the medical information, isn't really able to apply the medical information, isn't able to work, isn't able to provide for their meals and do their grocery shopping or things like that. And you've decided the person does need a guardian because maybe they don't have enough capacity to sign a power of attorney. The next question you're going to want to ask, and that's the most important one, is who is going to be your guardian? Now, I often find that people who, particularly with autism, because those kinds of challenges and impairments show up at a very early age. And so by the time the person gets to be 18 years old or an adult, they already have known for a while that this was coming. And so, usually it's one or both parents that end up taking that role. But not everyone has that available to them. Not everyone has parents willing to do it, able to do it, or that they want to do it. Unfortunately, some people aren't in a position where maybe their parents are the best person. And so it doesn't have to be a parent. It could be any competent adult, could be someone's guardian. And often there are situations where family members may not agree about who should be the person's guardian. And in situations like that, often a court will appoint a third person, and it could be someone that you don't even know. It could be just some attorney who maybe the court knows has experience with guardianships, and the court can just decide to appoint that person to be your guardian, whether you like it or not. So it's really important to think through before you ever file for guardianship, who is going to be your guardian, and whether that person is really going to be able to impress the judge that they're qualified to do that and that they will carry out their duties appropriately. Sometimes, if you get a guardian appointed and you don't like the guardian, there's an opportunity for you to have that guardian removed. But that's pretty difficult. You have to prove to the court that the guardian, not just that you don't like them, but that they're actually not doing their job, or that they're doing something that's been detrimental to you in some way. And if you're already, at the capacity where you need a guardian, that might be hard for you to do. So that's why it's very important to get that sort of mapped out before you ever start. The other thing you're going to want to do is have a backup guardian. In our state, we call it a standby guardian. That way, if there's some kind of a medical emergency, for example, and for some reason your guardian is not available, there's a backup person who could be contacted and who could step into that role and make those decisions. And so it's important not just to find a guardian, but also to find a backup guardian for yourself. Another reason to do that is, as I said, a lot of times it's a parent of a person with disabilities who becomes their guardian. And that's great in the beginning, but the reality is that, you know, let's say you're 18 years old and your parent is maybe 45 years old. That'll work for, you know, 20 years, maybe even 30 years. But at some point, your parent's going to get possibly to the point where they are no longer able to handle that for you. And in most cases, your parents are going to pass away before you do. And so it's also really important to think about who is going to be able to take over that role when the parents are no longer able to, or when they've passed away. So that's something you want to think about when you choose your backup guardian, is you're going to want it to be somebody at least no older than you, and younger is better. Obviously not too young, but you're going to have someone who can take that over when the parents are no longer able to. I run into situations all the time where a parent, I've got a 68-year-old woman whose 40-something son has autism and needs a guardian. And she's in a dilemma right now. She has no idea what's going to happen when she's no longer able to take care of those things for him. So that's another consideration you want to make. The other consideration is, as I said before, what the court is going to be doing is taking your decision-making rights and giving them to someone else. That means you lose them. And that can have real consequences for people. Sometimes, depending on how the guardianship is worded, you could do a limited guardianship and retain some of your rights, for example, the right to vote. But I've run into judges who don't like to mess with that, and they're just either going to do a full guardianship or they're not going to do one. And so you may end up with a full guardianship, even though you've tried to get a limited guardianship. And then, and certainly in our state, the law is written so that the guardian is supposed to allow the person with disabilities as much freedom as they're capable of handling. So even though the guardian can make all decisions for that person, they should consult with them. They should talk to them about the medical information to the extent they're able to understand. They should allow them to have input into those decisions to the extent they're able to. But you have to understand that ultimately, if the guardian doesn't agree with the person with disabilities about the decision, the guardian wins every time. They can overrule the person with disabilities once they've been appointed. And that can have really serious consequences. So again, it's really important that you have some kind of control going in over who your guardian's going to be. Another thing that you would have to think about is whether or not the person with disabilities is going to have legal representation in the guardianship process. And it's not the same in every state. I actually read an article recently about that. In my state, in Kansas, the law requires that if the person with disabilities doesn't have their own attorney, then the court has to appoint one for them. So in Kansas, you're always going to have an attorney when you're someone who is in a guardianship case and they're looking at appointing a guardian for you. That's not true in every state. I know some states are trying to change the law on that to make that the law, but it's not everywhere. So that's an important thing to know. If the court isn't going to appoint an attorney, then I would strongly recommend that you find a way to get one for yourself. And of course, then that's going to be an expense, because it's pretty rare that you're going to find an attorney who will take these kinds of cases without pay. It happens, but it's not common. And you might find some that'll give you a discounted rate, but you're still going to pay attorney prices for that person to represent you in court. And then all kinds of other things can come up in these court cases. And I'll go back to, what if your family members don't agree? You could have, for example, a situation where you have two parents. Mom thinks that the person needs a guardian. Dad doesn't think so. So what happens then? Well, then you're going to have a trial. You're going to have a hearing in front of a judge where the parties, your mom, your dad, or whoever's involved, puts evidence on about whether or not you need a guardian. There might be additional evaluations done, and you might have competing doctors saying different things. So those are kinds of things that you really want to think about before you ever file the case in court, because it's hard to stop once you've started it. In some cases, the judge will continue through the case and appoint the guardian, even if, one of the parents maybe decides that that isn't what they want to do. And I think I'm at the end of my list. So do you have any, I've kind of gone through a lot of information really quickly. Craig, do you have any questions that you think I should specifically address?
There was a question earlier in the chat by Miriam Havard. Hopefully I got that right. She asked, what should someone who is from, can you hear me?
Yeah.
All right. She was asking, what should a sibling do to help in a guardianship case?
Well, I mean, if it's an adult sibling, it's potentially the sibling could be the guardian, and that is actually happens in a lot of cases. The sibling can also talk about, what their personal, firsthand knowledge is of what the person with disabilities is capable of. And that can be really important with people with autism, and here's why. Often anxiety goes with autism, and there's maybe some fear there. There may be some anxiety about being in court, about being in front of the judge, about these, strangers talking about your life. And I think often people with autism will clam up and maybe won't be able to express themselves fully when they're in the courtroom situation, and maybe won't be able to display all the ways in which they actually are competent when they're under pressure like that in court. And so one thing that a sibling can do is testify, well, my experience with this person is that he or she is able to have these conversations and is able to understand these concepts. They're just nervous today and having a little difficulty communicating. It doesn't mean they don't understand. I think that's probably fairly common among people with autism, is that when you get in that stressful situation, you're maybe not able to converse and express yourself the way you can when you're in private with your family and you're more relaxed. So that's another thing that a sibling can do. And, they can also just simply support the person and help them maybe practice for going to court, go over some of the questions that you might be asked, and not coaching the answers, because you want the answers to be genuine, but you want to help them, understand how to answer the question in the best way, and maybe make sure that they understand the kinds of questions that they're going to be asked and why they're being asked, so that they give the right sort of answer.
Well, that's all the questions I have on my end. So thank you, everyone. And thank you, Kim, especially for giving us your time and that. Check out another video, and don't forget to subscribe, and have a great day. Bye.
What was that?